I think it's a really interesting topic to get into because it demonstrates just how many different things you could be thinking about when you're studying law. So, just to start with, as I said, something that's really brilliant about studying law is that you not only get to learn the rules of law, but you also have an opportunity to think and to argue about the principles and the goals behind these rules, and also the impact that all of this has on society. So, I mean, to start with, we might think, why should we have law, right? So, maybe one reason you'd give for having law is that law could help us prevent harm. For example, we could criminalize murder, we could criminalize theft. And if we do so, we might think that those things would happen less often and that would cause less harm in society. But that might not be the only thing that law helps us achieve. We might also have opportunities created through the law. So for example, I might have an ability to enter into a legally binding contract that both sides can rely on. That might help me plan my life out better. That might help me engage in business and so on. And in addition to that, you could also think about the laws helping us manage our coordination with each other. So a really helpful example of this is road laws. In this country, we drive on the left, and we do so to ensure safety and consistency on the road. It's not that driving on the left has to be the way that we do it. It's more that this is something that we all need to do together, and that helps us. So law could achieve a lot of different goals. We might have it for a lot of different reasons. Now, we might also think about how we should design the law. And we might first think about internal characteristics like the law being consistent or having a nice internal structure. So we might treat a rule against murder similarly to a rule against theft. Maybe they have similar procedural requirements. Maybe there's a similar burden of proof and so on. That could help us design law that's easier for people to understand and wrap their head around. And it might also have other potential benefits. We might also be interested in things like certainty, in things like efficiency, such as managing our relationships while minimizing any unnecessary costs. We might also like to look at equity, that people are treated fairly and equally, that those in similar situations are treated similarly. And we might also be interested in accessibility, in the sense that people can actually access, understand, and use the law to their advantage. Now, I mentioned all of these factors to get you thinking about the different things that might need to be considered when we're looking at what the law should be. But things like legal certainty and accessibility are only really relevant insofar as the law already exists. So then, of course, we go back to our first question, which is why should we have law? Now, again, to answer this question, we need to think about the things that we want to achieve with the law. And there's two principles and two things that I'd like to address today. Those are security and liberty. Now, both of these principles are interesting in that they're served in different ways in different areas of law. And they often might even be in tension, such that we need to think about how to balance them when we design laws and when we argue about laws. Now, I would say that the law can support security, and it can also support liberty. Sometimes those two might go together, and sometimes they might conflict. So the first example I wanted to talk to you all about is criminal law. Now, as a fundamental question, I want you all to think a little bit about in what circumstances is it acceptable to deprive someone of their liberty? So, what circumstances would it be acceptable for us to put someone in prison, for example? Might we think that it's acceptable to do that where a person would be a danger to someone else? What about if they're only a danger to themselves? What about if they're a danger to property? What else? What if they're a danger to something like the environment? What if they're not a danger to anything, but they do something that we think is, for some reason or other, morally reprehensible, something that we really don't like? Now, in addition to that, I guess the question really is security the only justification for depriving someone of their liberty? Now, you could have many different answers to this, and I want you to just take a little bit of time as we're talking to think about what you think about all of these issues. But what I could do to help you think about it a little bit more is give you some specific examples where this question of security and this question of liberty plays out in criminal law. So first, a good example is the legal burden of proof or standard of proof. Now, simply put, the legal burden of proof is a requirement on a party to a case to prove a fact which impacts the case in question. Now, the standard of proof is a standard to which the party has to demonstrate that something is proven. This is usually decided by the tribunal in the case, which could be someone like a judge or a jury. So in criminal law, the prosecution has a usual standard which requires them to prove most things, and they have to do so beyond reasonable doubt. So they have to prove some facts to the standard that the judge or the jury says, we feel beyond reasonable doubt that this has been proven. Now, commonly today, the word that's actually used is sure. So the standard is that you have to make the judge or the jury sure. Now, for defense, on the other hand, the standard of proof is the balance of probabilities, i.e., that something is not sure or is not beyond reasonable doubt, but instead is simply more likely than not. As I said, a lot of the time, the legal burden of proof will fall on the prosecution. So, for example, in a murder case, the prosecution will have to make the tribunal sure that the elements of murder have been satisfied. However, if the defendant wants to have a defense of insanity, for example, they then have to prove that that defense has been satisfied itself. And the standard to which they have to prove that is much lower. It's simply on a balance of probabilities. So there's a point here that the defense has less that they have to show in order to make sure somebody can stay free. Whereas in terms of security, in terms of putting people away and depriving people of their liberty, the prosecution has to do more. Now, another issue is bail. You could be put on bail when you're investigated by the police or even after being charged with an offence, but before you go to trial where you may be convicted. Being on bail effectively means that you're not held in custody, but bail may often have conditions attached to it. Now, bail conditions could be something like not being able to visit an area where an offence is alleged to have occurred, not contacting witnesses, certain reporting requirements, even residing at a specific place, or having curfew or electronically monitored curfew requirements imposed on you. Now, although these conditions do restrict what you can do, we might definitely look at them as at least being better than being in custody. And a rough idea is only to impose these conditions where it's necessary, reasonable, proportional, and capable of being enforced. Now, in English law, there's a presumption in favour of granting bail, but there are certain exceptions to this presumption. In other words, generally speaking, we want to leave people to their own devices and not hold them in custody when they are being charged with an offence and they might be convicted at a later stage. Now, the exceptions to this include things where if the court's satisfied that there's substantial grounds for believing that the defendant, if they are released on bail, would fail to surrender to custody, would commit an offence, would interfere with witnesses, or otherwise obstruct the court of justice. So the point here is, in criminal law as well, the balance between liberty and security is not an absolute one. There's not one decision which says we make sure everybody can go on bail at all times before they're convicted. Instead, we say this is going to depend on the facts and on the context in a particular case. What might the defendant do if they're put on bail? What is there a risk of? Now, another issue I'd like to talk about within criminal law is sentencing, which is effectively the determination of what sentence to give the defendant after they are convicted. So the trial finishes, the defendant is convicted, and a decision has to be made as to what their sentence will be. Now, I took these screenshots, there's two here, from the Sentencing Council's online guidance for determining sentences, and it's specifically for the offence of theft. Now, these guidelines are what is used in court, and a lot of similar guidelines can be found for other offences on the Sentencing Council's website. You can see the link at the top there for this one. Now, the point here is that although many different people could commit the same offence of theft, the law recognises that acts of theft and the circumstances surrounding them may be very different and may thus require a different type of sentence or a different length of sentence. Now, there's two major factors that need to be addressed. The first is on this first picture, which you have in front of you now. This is culpability. Now, culpability can relate to things such as the role played by the defendant, what they actually did, and how they planned it, if at all. So if you have a quick look at what's in front of you, you can see that somebody might fall under the category of high culpability, which is A, such as something which could include something such as taking a leading role, sophisticated planning, deliberately targeting a victim based on vulnerability. You might have medium culpability, which is a significant role, some degree of planning, some breach of trust or responsibility. Lesser culpability, which is like performing a limited function, being coerced to do so, etc. The point here is every single case is different. And in every case, even though somebody might commit the exact same offense, we might think they have a different level of blame, perhaps, and that should impact potentially the sentence that they have. Now, the second factor is harm. Now, harm can relate to not only the immediate loss that's suffered by those who've been stolen from, but also other consequences like emotional distress or impact on a business. As you can see here, there's 4 categories, and they relate to not only this particular amount of money, or the value of the goods stolen, but also the additional extra factors which might impact the harm that's been caused. So we look at culpability and we look at harm, and based on that, we determine a sentence for theft. So the different categories for each factor come together in this matrix. This is again on the Sentencing Council's website. We use this to determine the starting point for the sentence and the range which is allowed. Now, starting point is, without anything else being relevant, that's the sentence we're going to give. So if somebody has culpability of medium and has category 1 theft, we're going to look at category 1 and medium culpability, and the starting point in the top middle is 2 years custody. Now, the sentence could be made more or less onerous, and we see that the category range is 1 to 3 years and 6 months custody. Now, sentences can be made more or less onerous as well by reference to aggravating and mitigating factors. These are also set out on the Sentencing Council's website, and for theft, they include things like previous convictions, whether the offence demonstrated or was motivated by hostility towards the victim's religion, race, disability, sexual orientation, or transgender identity, whether steps were taken by the offender to prevent the victim reporting or obtaining assistance, and whether the offender has wrongly placed the blame on others. It also includes things like age and a lack of maturity, and any prospects of work, training, or education. So as you can see, these factors go beyond the offence itself and also consider the offender's broader actions and even what their prospects might be. All of this demonstrates that a balance has to be struck in every case based on the facts of the case. Now, taking a step away from criminal law, another area where security and liberty are both really important is public law. Both of these need to be balanced when we look at public law as well. Now, generally speaking, public law is concerned with the relationship between the state and the individual. So I want you to think about how that relationship can be managed and how managing that relationship might impact our goals of security and liberty. For example, should we allow the state to restrict our liberty if it's in the interest of ensuring security? We've already seen one area where this might be justified, which is criminal law. However, where does the state's power go too far? And where would the state itself be given liberty to act? So this question of liberty and security applies to the individual, but it also applies to states as institutions in and of themselves. Now, this issue might play out in a few different areas. The first of which could be the rules governing the judicial review of administrative decision-making. So the decisions of public bodies, they might relate to things like immigration, planning permission, licenses, granting licenses. And judicial review effectively allows courts to assess these decisions. And what courts are interested in is how the decisions have been made. Technically, they're not interested in the specific substance of the decisions. Now, in reviewing all these decisions, courts can rely on different grounds. In English law, there's a ground of illegality. In other words, that the decision maker has been wrong about the relevant law with respect to their decision making. There's a ground of irrationality, which is in English law called Wednesbury unreasonableness. That's satisfied if the decision in question is, and I quote, so unreasonable that no reasonable person acting reasonably could have made it. Now, this is a really interesting test, as it's harder to satisfy than simply asking whether the decision is reasonable. This gives a little bit more liberty and flexibility to public bodies. But then again, if public bodies are making decisions that impact the individual, it might inhibit the individual's own liberty. You should also note that there's a related ground of review which comes from European law called proportionality, which ensures that decisions only go so far as is necessary to achieve a certain aim. Now, another ground is procedural impropriety, which basically ensures that a procedure behind a certain decision is fair. That includes something like granting a fair hearing to people that are affected by a decision. So you can see and you can start to understand how in all of these, there's a question of how we manage the actions of the state, how we manage the state's relationship with the individual. Another really important aspect of public law is, of course, human rights. Now, in the UK, a really important piece of legislation is the Human Rights Act, which is a 1998 act. That act incorporates the European Convention on Human Rights into domestic law. Now, the convention was originally signed in 1950, following the Universal Declaration of Human Rights, all of which were looked to as a way to secure human rights in the aftermath of the Second World War. I think today in this country, a lot of people might take for granted the importance of maintaining strong rules in support of human rights. Now, some of the rights involved in the convention include the right to life in Article 2, the prohibition of torture in Article 3, the prohibition of slavery and forced labor in Article 4, the right to a fair trial in Article 6, freedom of thought, conscience and religion in Article 9, the freedom of expression in Article 10, and of assembly and association in Article 11, and the prohibition of discrimination in Article 14. It's important to note that many of these rights are qualified, which means that public authorities are allowed to interfere with the exercise of these rights, except where in accordance with the law and necessary in a democratic society for certain interests of that society. Things like the prohibition of torture in Article 3, however, are absolute, meaning that nothing can ever be justified by way of interfering with it. The public authorities cannot interfere with these rights. Examples of qualified rights, on the other hand, include the right to respect for private and family life in Article 8, and another important right, which is the right to liberty and security in Article 5. Now, we can start with Article 8, which sets out the right to respect for private and family life. Now, I'd like you to just take a moment to have a quick look at this paragraph. So the first part of the article, the first paragraph that is, sets out the right. And the second one says that public authorities are not allowed to interfere with it except in certain circumstances. Now, I want you to think about what this right achieves. It might make people more secure in the sense that their private lives and homes will be respected, and might also support their liberty in the sense that these things cannot be interfered with except in certain circumstances. But what about the state side? The article clearly imposes a restriction on what states can do, but it also recognizes that states may need to interfere with the right in other circumstances. If you look at the circumstances referenced, these include things like safety and protection of others. Now, this point might come up in criminal law as well, which is that we need to recognize that the liberty of one person might result in danger to others. Once again, there's a balance that needs to be struck here, and this article recognizes that. Another article is Article 5, where we can see that the right to liberty and to security is also qualified. Now, it's quite interesting that Article 5 groups these two together, because I've sort of been suggesting today that liberty and security might conflict. And they do, but they also might go alongside each other. Sometimes having security enables you to be free and to have liberty. Now, the fact that this is also relevant here and also sets out quite detailed exceptions where the right can be interfered with or somebody can be deprived of their liberty connects back to the criminal law issue, but also highlights that this article is itself striking its own balance. And there's a point to be made here, which is that the balance struck between these two factors depends on the specific context. Again, it's not that security and liberty are outweighed in certain circumstances and are paramount in others. It's that everything depends on what's happening, who's being affected, and what the state is doing. Now, the point about human rights brings us to another important area of law, which is international law. Now, as I suggested, international law is really relevant for human rights as well, because we have a European Convention on Human Rights, and that really is where human rights in the UK come from. So, in brief, international law concerns the relationship between different states. I'd like you to think about how that relationship can be managed and the implications, again, that this might have on security and on liberty. Now, a really important point here, which I've alluded to earlier, is that these goals are not only of concern to individuals, but also of concern to states. States as a whole might want to be autonomous in making their own decisions and may be seriously interested in ensuring that they stay secure and safe. And that could be both politically and in terms of the safety of their constituents. However, sometimes that safety might come as a result of cooperation, of engaging with other states, for which some of their liberty has to be given up. So the first example, again, to highlight here is the European Convention on Human Rights. Now, as I said, our Human Rights Act incorporates this convention into domestic law, and it also has quite a wide-ranging effect in relation to other elements of UK law. But the convention also stands alone as a part of international law. Human rights cases can go to the UK courts, but they can also go to the European Court of Human Rights in Strasbourg. It should also be noted that under Section 2 of the Human Rights Act, the judgments of the Strasbourg Court relating to convention rights must be taken into account by the UK courts. Another example of really important international law that impacts the issues we've been talking about is the Geneva Conventions. Now, these are conventions which set out various legal rights relating to armed conflict. The conventions themselves deal with armed conflict between two states, two or more states, and they concern things such as the treatment of the wounded, the treatment of prisoners of war, and the protection of civilians. However, another important element of all of this are the additional protocols to the conventions. These concern victims, the display of a medical emblem, which is an emblem of a red crystal, basically allows medical professionals to be protected by all parties during times of war. And quite interestingly for our purposes, another protocol deals with non-international armed conflict. In other words, that's conflict that takes place only within a single state. That protocol effectively stands as an example of international law restricting the liberty of a state, even when a conflict is only within that state, and doing so in the interest of protecting those affected by these conflicts. Now, a note here on the slides that these conventions are again enforceable in domestic courts, but also in the International Criminal Court. So again, there's this point here about what states are allowed to do and whether restricting states and potentially restricting people by having more rules that they can't get away with breaking actually gives security for other people. One more example to address is EU law. Now, the EU is a really wide-ranging institution today, but it's always been developed with the idea of European integration in mind, especially in terms of a union between European countries after the Second World War. Now, the first step towards the modern EU was the European Coal and Steel Community, which mainly included Western European states. But since then, more states have joined as the collective became the European Economic Community and eventually the European Union that we know today. Now, as this has happened, the EU has become involved in many areas of law and society, moving beyond simply economic issues to issues of health, consumer protection, labour rights, data protection, environmental regulation, and so on. What's really interesting within our context is that the EU achieves its goals in these areas in different ways. So this is a screenshot from the European Union's own website, where it talks about some of the legislation that exists in the EU. Now, it's not mentioned here, but the most important and first piece of legislation that's relevant for the EU are the two treaties. The European Union in its current form exists by virtue of a treaty on the European Union and a treaty on the functioning of the European Union. Now, these treaties deal with a lot of constitutional and procedural issues, but they also set out key rights of member states. In addition to these treaties, however, the EU has regulations, as you can see on the slide. It also has directives and has decisions, amongst other things. Now, regulations are specific European legislation, which itself is binding on member states. These are legislative acts that are decided and enforced and implemented in the EU, and which all member states have to follow. Directives, however, instead of prescribing the rules that need to be followed in detail, instead set out a requirement that member states need to meet through their own domestic legislation. Now, I should note that the legal status of directives as themselves having effect domestically is a little bit more complicated than that. But what's important to understand today is that even in lawmaking, the EU recognises that states should have some liberty in determining the specific rules that they implement in certain circumstances. Now, traditionally, part of the reason for that is that we recognise that different states, even within Europe, have different economic, cultural, political situations. So directives are a really interesting example of an area where states are being constrained and their liberty is being constrained. It may often be for constraining their own constituents, or it may be for securing the liberty of their constituents. But through these directives, the states are still given freedom. They're still given liberty to implement the laws that they need to implement in their own way. Now, that being said, the European Union can also implement decisions which deal solely with a specific member state. Now, that might not be the example you have in front of you regarding to Croatia adopting the euro, maybe isn't an example of constraining the liberty of member states in question. But you could think more generally that the EU could adopt a decision which says to one member state that we are deciding that one of the things you're doing is wrong, for example. So the point stands that the EU can directly limit the autonomy of states. But this interplay between security and liberty, this interplay between how far we can go in restricting what people and what states can do, means that even something like EU law has got different elements and different forms for different circumstances. Now, before I conclude and let you all ask some questions, I wanted to highlight the fact that a lot of other areas of law are also interested in these issues of security and of liberty. One example of that is contract law. Now, in contract law, there's a principle called freedom of contract, which is basically intended to allow parties to choose freely what they agree to, i.e., I could pay whatever price I want for the goods that I would like to buy. Even if somebody else thinks it's a silly price to pay, I have freedom of contract. Now, freedom of contract is limited by legislation such as the Consumer Rights Act, the Unfair Contract Terms Act, and some other things. Now, these two acts I've mentioned here both require that certain terms of contracts are reasonable, and this protects parties from really bad agreements in certain circumstances. So the point can be made here that people's liberty is being constrained, again, potentially in the interest of security. Another example is tort law, which effectively creates an obligation for parties to act in certain circumstances where the law treats them as having a duty of care. Now, such a duty might exist where somebody assumes responsibility for another person. That might mean that doctors are obligated to act to a certain standard to assist their patients. However, where there's no such duty of care, a person will not be liable under tort law, under the tort of negligence, to fail to act to help somebody that they did not themselves harm. So again, there's a balance being struck here, and there's a lot of debates as to whether the balance struck is the right one. Another example, which I can't not mention, is taxation law. And in taxation law on the international level, states themselves will form agreements with each other relating to the specific tax treatment of persons that live or work in multiple countries. Now, such agreements might make it more possible for these persons to actually move freely, to travel and maintain their lives in multiple places. These rules and these agreements between states actually create some liberty for these individuals. But the rules can also work to ensure that these persons still end up paying taxes somewhere, and in that way might be looked at as constraining their liberty. Now, just for a few further points, I'd like to mention that balance, again, is a really important factor here. But a lot of characteristics and a lot of principles that you think about when you look at law and when you study law have to be balanced. There might be other things outside of security and liberty. You might look at consistency and flexibility in the law. In other words, for example, if somebody commits theft, do we always consistently charge them in the same way and give them the same sentence? Or do we recognize that we need to be flexible and recognize that other people's situations are different? You might have something like simplicity versus complexity. Should we have simple rules to ensure that everything is certain, is easy and clear to understand? And when do we need complexity to make sure that everything is dealt with and every little scenario we can think of is dealt with? You might say it's not even ever possible to deal with every scenario, but we might want to try anyway. When might we want to make people cooperate with each other, both on an economic level, but also on a state level? And when might we want to encourage competition between parties? The point is here that a lot of things have to be balanced. and there's often not a right answer. This is something that I think is really interesting about law, and I hope it's inspired you to have a little look at studying it. Now, there's a few other goals you might be interested in as well, because as I said in the beginning, it's not just security and liberty that are relevant here. We might be interested in behavioral incentives. For example, we might want to ban the use of certain drugs to encourage people from not using them. We might be interested in economic results. We might want to design, for example, a tax system in a way that supports the economy. There's a lot of other things to think about here. And the beauty of studying and reading law is that you can think about these issues and you can incorporate them into your own arguments about the specific rules that you've been learning. That last point makes the same point that I've just said. So again, you get to study all these really interesting rules. You get to study how they work together. You get to try to apply them, but you also get to criticize them. And you get to think about how to make them better. And that's something that's really interested me since day one. And I'm sure all of you are more than capable to have a go on your own. So I encourage you to have a think about this. I hope you've enjoyed this talk, and happy to answer some questions now. Thank you.